Uh, I would like to begin the webinar on the recent judgment passed by Supreme Court in respect of invocation of bank guarantee. Before we do that, it is my duty to introduce myself to you. I am Advocate Parth Pati, and I am a partner in Abhay Nevagi and Associates, which is a law firm based out of Pune, and we have offices across India, namely in Mumbai, Ahmedabad, Delhi, and Kolhapur. And the firm specializes in all areas of law. It's a full service law firm. So the idea of today's webinar is to primarily discuss and try to critically analyze the judgment of the Supreme Court. I will take you through the judgment. I'll not go into the facts because facts are something that you can obviously cull out from the judgment itself. I would advise you to go through the judgment as well so that you can draw your own inference in the process. I have drawn mine. And I am skeptical in the age of intolerance that is prevailing today. I am skeptical when I make this particular presentation in front of you, that to live. I hope I am able to uphold the dignity and respect of our higher and lower judicial institutions. So, friends, what is bank guarantee? Now, bank guarantee, BG, letter of guarantee, performance guarantee, corporate guarantee. There are various advance payment guarantee. There are various forms of guarantee that you come across in trade parlance, which has got specific purpose behind it. The primary being trust. I think why you need guarantees is to build in trust, and sometimes this trust can be documented in the form of bank guarantee. I have tried to explain what bank guarantee is. I have taken this definition from the website of ICICI Bank, and as evident on the screen, if you are seeing the screen, then a bank guarantee is basically a promise, but in the form of a contract primarily from a bank that liabilities of a debtor will be met in the event you fail to fulfill the contractual obligations. So basically, bank is guaranteeing the fact that if a particular party fails to meet his liabilities, his contractual obligations, then the bank will pay the other party in business the amount that has been stated in the terms of the bank guarantee. Bank guarantee is basically a form of contract. It's a guarantee is a form of contract, and so is a bank guarantee. However, one of the most important factors that you need to keep in mind is that this contract, the bank guarantee in the form of a contract, is between the bank and the beneficiary. Beneficiary means the person in whose favor the bank guarantees has been given. It is not a contract between the applicant and the bank. It is not a tripartite contract for that matter. It is a contract solely between the beneficiary and the bank. Now, I would like you to hold on to that particular thought, but that particular principle, because we will delve into the matter. When we delve into the matter, this particular aspect acquires a lot of significance. Now, again, I have referred to the bank guarantee. How does a bank guarantee work? I have taken certain directions from the ICICI Bank website. Thank you for that, ICICI Bank. So basically, an applicant is generally an account holder in the bank. He has been banking with the particular bank for a long period of time, and the bank realizes that he's a safe horse to bet on, basically. So the applicant and the beneficiary first enter into a contract and agree that there has to be a bank guarantee. There are various conditions, the various situations when such an event occurs. For example, in the case of a business transaction wherein one party is buying, the other party is selling, so the buying party may take a bank guarantee from the selling party that in case the money has been paid by the bank, paid by the buying party, then it is incumbent on the seller to basically sell the products at the right time. And if he fails to do so, then the buyer can invoke a bank guarantee. So there are various situations wherein this kind of a bank guarantee can be issued, and an applicant approaches issuing bank to issue bank guarantee in favor of the beneficiary. So applicant, who is generally a bank account holder, does this, and the bank issues a bank guarantee and couriers the hard copies to the bank guarantee to the beneficiary and notifies the applicant of self collection of the branches. And the bank guarantee can be invoked by the beneficiary as per the terms of the bank guarantee. I am not getting much into the workings of a bank guarantee, since it is uh, a trade practice, and I think understood by most of the people. Now moving on, uh, we will be, let us understand what this particular judgment is. It is numbered as Civil Appeal 14015 of 2015, Adani Agri Fresh Limited versus Mehboob Sharif and others. Sorry for that. So the date of judgment is 2nd of December. The quorum was Jagdish Singh Keher, Justice Jagdish Singh Keher and R. Bhanumati. The order appeal against is the order by Karnataka High Court in writ petition number 4654 of 2012. So just to give you an idea of what this particular case is about and the origins of the case. Now, the primary ratio, and I have taken the liberty of taking this particular part of the ratio from the judgment itself. The judgment has done nothing new. It has reiterated an already established principle of law, which says that a bank guarantee, an irrevocable bank guarantee, is capable of getting invoked by the beneficiary on the occurrence of such situations as may have been mentioned in the bank guarantee document, in all respects and in all situations, except when there is a egregious, flagrant fraud, or there is a possibility of irretrievable injustice or injury. Now, big words, of course, and our Supreme Court is obviously has a penchant to use this kind of words while delivering its judgments. Obviously, it makes the work of lawyers more important, and interpretation of law becomes a business. And through this, by giving this kind of judgments, what Supreme Court does is it allows scope for interpretation. Now, as we go further, I'll tell you as to why this kind of judgments have to be looked upon. Have to be The Supreme Court has to give it a second thought before passing this kind of judgments. The judgment is academic in nature, purely. If you can see on the screen, the judgment has referred. It has quoted from several past judgments of the Supreme Court itself, and the judgment throughout the text of the judgment, it is clear that it is a settled law. The ratio that I just showed you in the previous slide, for your benefit, I'll again show it to you. That no injunction can be granted against invocation of bank guarantee unless there is a egregious, flagrant fraud or the possibility of irretrievable injustice or irretrievable injury. So this is something. This ratio is a ratio which is settled, and incidentally, the Supreme Court has dealt with this matter on multiple occasions, and they have given very clear cut. The mandate is clear cut. Some of the judgments that this particular judgment of Supreme Court refers to are shown on the screen. I'll read it out for you. UP Cooperative Federation Limited versus Singh Consultants and Engineers Private Limited, 1988, Volume 1, Supreme Court Cases, page number 174. Vinitech Electronics Private Limited versus HCL Infosystems Limited, 2008, Volume 1, Supreme Court Cases, page number 544. Himadri Chemicals Industries Limited versus Coal Tar Refining Company, Mahatma Gandhi Sahakari Shakare Karkhane versus National Heavy Engineering Corporation Limited, and another. And and then the judgment has also referred to a few cases. I think one of the cases from the US courts, which was referred to in UP Cooperative Federation Limited and Singh Consultants and Engineers Limited. So uh, now, although the judgment is academic, but the judgment uh, appears to be a reiteration of what all judgments have been given by the Supreme Court on the earlier occasions. So what I'm trying to say here is that the judgment could have gone further and analyzed the issues further, could have laid down a test to analyze, to understand, uh, for the benefit of the judiciary, lower judiciary, as well as for the benefit of legal luminaries, as to how to deal with the situation if it arises of the same kind. Now, let us understand the features of the bank guarantee, which is the subject matter of this case. In this case, the applicant of the bank guarantee was Mehboob Sharif, who is the respondent number one in the matter. The beneficiary was the Adani Agri Fresh Limited, and the bank and the guarantor was the State Bank of Mysore. Uh, so now Adani AgriFresh is the appellant in this particular matter before Supreme Court, and State Bank of Mysore, I think, is defendant number 2 and 3. So there is one branch in Mysore and there is one branch in Gurgaon, if I'm not wrong. The terms were clear. It was an unconditional guarantee. And the most important part of the bank guarantee, which is to be taken into consideration by all, is that the guarantor had expressly waived off rights of any objection and defense, irrespective of disputed positions adopted by the contracting parties or even the validity and legal effects of such contractual agreement. What it basically means is that even if there was a dispute raised by the applicant against the beneficiary, the guarantor would have no issue with that. The guarantor would respect the bank guarantee and allow it to be invoked. Primarily, this is what the bank guarantee terms and conditions had in mind. Now, on the basis of that, we can look into the facts of the case. Now, I am not delving into the facts of the case for the sole reason is that you can find the facts of the case in the judgment itself. What I'll do, however, is verbally take you through the basic aspect of the judgment, which I think is important. Basically, in this case, Adani AgriFresh was supposed to sell apples and fruits to to the company of Mehboob Rahman, the defendant number one in the concerned matter, and this apples were to be sold to Mysore. So basically, the company Adani AgriFresh was going to ship apples to Mysore to Mr. Mehboob Rahman and Mehboob Sharif, rather. Pardon me for that. And raise invoices and then take money from Mr. Mehboob Sharif. Simple business transaction. And to ensure that payments were made in time and the contractual terms were respected, a bank guarantee was taken by Mehboob Sharif in favor of Adani AgriFresh. There were 3 bank guarantees that were taken from time to time, and all the terms and conditions were the same. State Bank of Mysore had given the bank of guarantee, and in case a claim was raised by Adani AgriFresh that payments are overdue, or a certificate was issued by Adani AgriFresh that payments from Mehboob Sharif have not been received as per the terms of the contract, then unconditionally and without demur, without asking any questions, the State Bank of Mysore was supposed to allow the bank guarantee to go through, and the bank guarantee could be invoked in the process. So this was a simple transaction. Now, what had happened is that a certain consignment of apples that was sent by Adani AgriFresh. No, let us not get into that. Let us first understand that what happened. So there was a pending total dues pending to the account of Mehboob Sharif came to as 62 lakhs. And Mehboob Sharif was requested by Adani AgriFresh to pay the money. However, Mehboob Sharif did not pay the money, and therefore Adani AgriFresh went to State Bank of Mysore and invoked the bank guarantee. Now, when such an application was made by Adani AgriFresh, Mehboob Sharif, who is the defendant in this particular matter, approached the civil court, the civil judge junior division in Mysore, and sought an injunction against invocation of bank guarantee. And apparently, and this particular injunction was allowed by the injunction was allowed by the civil judge junior division Mysore. And then against this interim order, Adani AgriFresh approached the Karnataka High Court in writ petition, and even Karnataka High Court did not tamper with the order of the lower court. And against this order of the High Court, Adani AgriFresh approached the Supreme Court in this matter, and the Supreme Court has dealt with the matter by laying down the fact that a particular bank guarantee, which is irrevocable and unconditional, and the kind of terms and conditions that were mentioned in the bank guarantee, which is the subject matter of this case, there can be no right, there can be no order to injunct the bank guarantee from getting invoked. So under no scenario, such a bank guarantee could be stopped from getting invoked. So Supreme Court has reiterated the entire law. However, the Supreme Court has laid down, by reiterating the laws, reiterating the already existing settled law position on this matter, Supreme Court has said that in case of fraud, egregious and flagrant fraud. Now, Supreme Court has not decided, not laid down any parameter for those kind of frauds which can be identified as egregious or flagrant frauds. And what they have done is that they have reiterated the judgments. So what Supreme Court says in this judgment primarily is that unless and until there is a fraud which is of magnanimous proportion, or a fraud which is too obvious, and it is a very you can say a very serious fraud, then in that case, and the knowledge of the fraud, the bank actually has apparent knowledge of the fraud, then in that case there is a possibility that the bank can be stopped from invoking the bank guarantee, or the beneficiary can be stopped from invoking the bank guarantee. So this is a particular scenario when there is apparent fraud. Say example, the beneficiary of the bank guarantee has approached the bank with a fraudulent way of functioning and has tried to obtain the bank guarantee. Then in that case, the applicant can take a plea that there is a fraud, there is a case of fraud, apparent fraud, and therefore the bank guarantee should not be invoked. Now, this is very similar to a provision in CPC that nobody can approach the court with unclean hands. I can draw a parallel between these two. But my only query that arises in this sort of a situation is, what is the definition of egregious and flagrant fraud? Now, a fraud is a fraud. Now, how can I be expected as a litigant to calculate the degree of fraud? Now, has the Supreme Court, by using this words egregious and flagrant, have tried to say that there is a particular degree of fraud in case of which an injunction against bank guarantee can be given? So has the Supreme Court tried to do that? If it has, then why has the Supreme Court not laid down the parameters? Since there are judgments from 1988 apparently on this subject matter which are very clear, then Supreme Court had a very good opportunity this time to lay down those parameters of fraud. Then why has Supreme Court held back? That is my query, and that is my worry also at the same time. So fraud, egregious fraud, flagrant fraud, definition, difference, parameters, test is what I expected from Supreme Court. Supreme Court is a law-making body. It is not a law interpreting body alone. It is also a law-making body. So Supreme Court had the opportunity, and I think Supreme Court should have exercised that opportunity of laying down the tests, defining what egregious and flagrant fraud meant, and laying down the parameters of what can be considered as a egregious or a flagrant fraud. Moving on, the other scenario under which an order of injunction can be passed against invocation of bank guarantee is the possibility of irreparable injustice or injury. Now, is this similar to irreparable damage? That is my second question. Now, we all know that the injunction for an order of injunction to pass, you have to basically satisfy the three tests: prima facie case, balance of convenience, and irreparable damage. Right now, by using the words irreparable injustice and injury, has the Supreme Court is the Supreme Court pointing to something else, or is it similar to irreparable damage? Is the degree of proof that is required to prove irreparable damage is the same for proving irreparable injustice and injury? That is my second question. I think the Supreme Court has failed to answer these questions, and that is again my concern of a very hands-off approach of Supreme Court, wherein Supreme Court does refer to the previous judgments, four of them actually, and but refuses or fails to clarify them completely when they had an opportunity to do so. My other query and my other question that is of significance is that violation of Article 141. Now, in terms of Article 141 of the Constitution of India, the judgment of Supreme Court is basically the law of the land, and all lower courts and tribunals are bound by the said law. Now, in spite of a category of judgments that I have referred, that the Supreme Court in this matter has already referred, how is it possible for a lower court in Mysore, civil judge junior division in this case, and the Karnataka High Court to have issued injunction orders against invocation of bank guarantee? Karnataka High Court actually confirmed the order. They do not issue the order. The order was issued by the civil judge junior division. So, how can this nature of unconstitutional behavior on the part of the lower judiciary and the higher judiciary be allowed by the Supreme Court? That is my second question. Why has Supreme Court not come down heavily on the lower court and the Karnataka High Court in this matter? When it is a settled law, when a settled law passed by the Supreme Court over the years has come into effect, and it is settled by Article 141 of Indian Constitution, how on earth can a lower court in Mysore and the High Court of Karnataka not adhere to the principles laid down by those Supreme Court judgments? This is a concern. This is a aspect which each one of us has to be worried about, because this shows lack of judicial discipline, and it is time that Supreme Court did not allow this kind of judicial indiscipline, because it creates confusion. And the modern world of social media, this kind of issues have to be taken up. It is our duty, so that the Supreme Court also realizes and acts accordingly. And even the lower judiciary and the higher judiciary is more careful when they pass judgments of this nature. So with that, I would like to conclude my webinar. Thank you for all the participants who were there here. And in case of any questions, please shoot. I am here for the next 5 minutes. I'll be happy to answer those queries. Thank you. You can also contact me or my firm on the given details, address details that are appearing on the screen. Thank you, everyone. I'm here so you can feel your questions.